Right, I would be grateful if it could be made clear to the transcribers that their computer equipment is not the only computer equipment in the world. I do not want two screens with Opus 2 on it. I'll have one transcript with one screen, and that's it on the left-hand side. And please, if they cannot during lunchtime, come and disturb all my own computer equipment, because I actually do not use paper.
My lord, I'm sorry, and we'll make sure that that happens tomorrow morning.
Thank you very much. I know it's my own fault because I haven't got a clerk. Good, thank you. Sorry, Miss Sutton. Please continue your submissions.
Thank you. So before we broke, I had taken you to the transaction premium clause and the basis evaluation clause, shown you how they sit relatively to each other, and made the submission that the reasonable reader would not reach the view that the transaction premium clause was merely some sort of icing on the cake in relation to the measure of indemnity. In fact, the picture gets worse for underwriters, looking at the structure of the contract as a whole, which is where we are. The most important point is the repetition of the clause in section 4. The judge held at paragraph 302 that that was the clearest indication that the parties intended the clause to be a separate insuring provision. And Mr. MacDonald-Eggers, with respect, had no answer to the court's question as to why, on his case, the clause is repeated and is put in a separate section. Putting on the hat of the reasonable reader again, what would the reasonable reader, the reasonable policyholder, conclude from the inclusion of this clause in the contract twice? Well, two things. One, it's intended to be important and add something substantial, not merely peripheral. It's inconsistent with the icing on the cake argument. But secondly, they would also conclude that this is a freestanding head of cover, and that is why it is put in a separate section, as well as in section 1, a section which contains some provisions which are applicable to the policy more generally. Now, those are the most important points, but I do just want to highlight one or two other points in the policy. If we go back to the very front, please, page 360, it's at the start of tab 10 of the bundle, page 360 of the hard copy, 365 of the PDF. The insured there is defined as the bank in various guises and I-star BV. I mention that because everybody always understood that the assured under this policy was a bank. So when one reads at 4 pages on page 363 under the general conditions, the general intention to protect the interest of the insured at all times and in all circumstances, that's the first paragraph of the general conditions, what the parties were contemplating was the interest of a bank being protected broadly. I also mention that definition of the insured because it refers to subject matter insured, the owner of the subject matter insured, as such term is defined in section 1 conditions, subject matter insured. So one might think that you look to section 1 to see, indeed, what is the subject matter of this contract. And I will come there in a moment. But first, please, page 361 of the bundle, 366 of the PDF. You see there, and we're in the preliminary section of the slip, we haven't got to the heading section 1 yet. You see there at the bottom of the page the interest provision. This is where the policy refers to goods, not in section 1, but in the first part under interest. Goods are here, all goods and merchandise appertaining to the insured's business, and this is put broadly, for which the insured is the legal owner or for which the insured is at risk or responsible contractually or otherwise. 2 points. Number 1, it's broad. Number 2, it's interested in contracts and the bank's contractual exposure. Then at page 362 of the hard copy, 367 of the PDF, we have the basis of valuation clause for the first time of asking. Why isn't the transaction premium clause here if the TPC is some form of elaboration of the basis of valuation in this contract? That too is inconsistent with the underwriter's interpretation. We then come back to page 365, which would be 370 of the PDF. Section 1 is headed Conditions, Subject Matter Insured, and then that's almost repeated underneath, Subject Matter Insured, the interest. There is no definition separately in this section of subject matter insured. It is perfectly true that the words are used several times in a context which makes it clear that in that context they're referring to the goods. But the only definition in this contract of the subject matter insured is here, section 1. So this is where you look in this contract to see what is insured. So what is insured? After some provisions about limits and location, at page 366 we get to the very heart of things. The shipments clause. All shipments are covered under this contract. Language of coverage. What else is covered? Storage risks. The insured may declare a storage risk. So storage risks are insured. Next page, page 367, or 372 of the PDF, transaction premium clause comes in for the first time of asking. Underwriters agree that the insured is covered under this contract for the transaction premium clause. So why put a line through transaction premium when it is clear that here is where you find what is covered under this contract, and it follows sequentially from shipments and storage risks? Now, my lord, you asked Mr. MacDonald-Eggers, well, why is the transaction premium clause in section 4? But one might also put that question the other way round. Why is it in section 1 as well as section 4? Well, the answer to that may be precisely to see off Mr. MacDonald-Eggers' submission on subject matter insured by listing it in this section, the central part of the policy, which tells you about interests insured. It is putting a line through the Frio Chili argument. It's making it clear that the parties intend the transaction premium clause, the transaction premium, to be one of the subject matters insured under this contract.
What Mr. MacDonald-Eggers says is that when you look on page 365 at subject matter insured, it refers to the interest, and you have to look back to the earlier definition of what is meant by the interest, which of course defines that as the goods.
Well, that's true, but that doesn't take you very far, because it's defined there as interest. Whereas, and I took you at the start of the policy to the reference to subject matter insured as defined in condition 1. That's one, in fact, of several places in this policy which take you to subject matter insured. But I'll come back to this when I deal with the Frio Chili, but it's really a non-point, the subject matter insured, if the contract is clear enough what is being covered. And my essential point is that it really is clear where you have a contract which includes a clause both within the list of subject matters insured in section 1 and in its own freestanding section. And why would you do that if it was to be a measure of indemnity provision only? It's surely there to make it clear that it is a separate insuring provision in its own right. Now, the final point that I want to make under this heading, and I'm dealing here with construction, is how a reasonable reader would understand this clause, is that as a result of the rectification arguments, the judge actually had a lot of evidence before him of how a number of different interests had actually read this clause. Now, I accept, of course, that evidence of subjective intention or subjective understanding isn't relevant to construction. But my submission is that in this case, where there was evidence from lawyers, brokers, underwriters, the bank, and they all had the same understanding of the clause, it is optimistic for Mr. MacDonald-Eggers to submit to this court that a reasonable reader would read the TPC only as he says and not as a freestanding clause. So if I may, I'm just going to give you the references to where the judge dealt with people's understandings. It's paragraph 57, dealing with the lawyers who drafted the clause. The clause was drafted by specialist insurance lawyers at Norton Rose, and they understood the clause to create cover for financial loss if the bank's counterparty defaulted, irrespective of physical loss or damage. Then it's paragraph 75 for the brokers. Mr. Lockyer of the brokers made a note at the time which said that he understood the clause to allow the bank to seek indemnity without any physical loss or damage. His contemporaneous words, these aren't tainted by hindsight. Then judgment paragraph 81 for those at the bank. They weren't insurance lawyers, but they reflect a reasonable policyholder. They understood the clause to create credit risk cover, the bank says. And then finally the underwriters, and really the core of this is paragraph 417, but you will want to look back to paragraphs 157 and 159 to understand fully what's said here. When this claim was first notified, Mr. Beattie was consulted, the judge finds, and following a discussion with Mr. Beattie, RSA confirmed cover under the transaction premium clause, appreciating at the time that there had been no physical loss or damage. As the effect of what the judge found, you do need to go back to the paragraphs to put it together. So it was only some 8 months or so later, in August 2017, after lawyers had become involved, that the claim was declined and the current position on the meaning of the transaction premium clause was taken. So were these all unreasonable readers, is the question I pose in our submission. Not. So I'm going to come on then to my second heading, which is about factual matrix and commercial sense. The underwriters contend that the judge erred by not construing the transaction premium clause with sufficient regard to the factual matrix and the context in which the policy was placed, but we submit that he was wrong. And I'm going to develop 4 headline points. And the first is a point I think I've touched on already, which is that the way in which the judge framed the question of construction itself took into account the factual matrix and the nature of the policy. And that's the Engelhardt point, that the Engelhardt formulation, if I may call it that, of asking, is the wording clear, is born of the context that you're looking at a wording placed with cargo underwriters and included within a marine jacket. And again, I'll just give you 2 references, if I may. The first is to the paragraph 179 of the judgment, where the judge says that the authorities show the importance of considering the wording of a particular clause in its contractual context. So he fully understood that. And then the second is to paragraphs 39 and 41 of the Engelhardt case. In both places, the judge uses the words the commercial context to explain the approach to construction that he's taking. So that's my first submission, that actually context and the cargo market context was in from the start and in the whole way that the judge approached this. Then my second point is equally short, and is that the judge in fact took into account all of the underwriter's arguments in relation to commercial absurdity in the factual matrix. And the reason that I can make this point shortly is that underwriters list in paragraph 14 of their own skeleton argument the matters which they say were not properly taken into account in relation to factual matrix. But in each case, the paragraph ends neatly with a reference to where the judge made findings about them. So this isn't a case where an appellant is coming to you and saying, look, there was some other really important matter, it's just not here in the judgment. The judge didn't take it into account. They're there. The judge did take them into account. And that was hardly surprising. The judge was steeped in the factual matrix. He'd had 5 weeks of evidence, 24 factual witnesses, expert underwriters, expert brokers. The judge was steeped in these points. It was what the trial was about. Then my third point is that the commercial sense arguments were not all one way. And this is at the heart of why the judge was unimpressed by the points which the underwriters were relying on. And there are 2 aspects to this. There's the broader commercial picture about the market generally, and then there are narrower arguments about the sense of the transaction premium clause within the policy. That's about the non-plod or are they non-plod add-ons. So starting with the broader commercial picture, again, I want to just pick up 3 points from the judgment, and they are first at paragraph 209. The underwriting experts agreed that non-plod extensions, sorry, plod physical loss or damage, non-plod extensions were available in the market. That's a finding of fact which is not and could not be challenged, but it isn't addressed anywhere in underwriters' written or indeed today in their oral submissions. And against that background, the question of whether the extent to which particular clauses, other clauses in this contract were or weren't non-plod additions becomes actually rather unimportant. It wasn't a particularly surprising thing to be doing in this market, is the point. Certainly, saying that because it's the cargo market alone, it's extraordinary to have a non-plod add-on is contrary to the evidence before the judge. Then the second point is paragraph 213, where the judge made some findings about the market generally. And this is pretty remarkable evidence. Not only was the market soft, people were, in the words of one witness, slapping down lines. In the words of another, it was a wee circus. In the words of another, the most extreme pressure on pricing the market had seen. That's pretty remarkable evidence, and it's unsurprising against that background to agree a broad add-on for a desirable client, a bank. Then the third point I've already mentioned is paragraph 275, and that's the judge's findings about the bank's repo financing and the fact that its business was unsurprising. And the reason I mentioned this point in this context is that it's unsurprising that the bank should seek to protect its book in the widest possible way. And as I've just said, if you ask the question, what are the interests of the insured at all times and in all circumstances, per the rubric at the start of the contract, it clearly covers the bank's interest in being repaid. And as a financing institution, a bank, in all these respects, the bank ultimately only had one interest in these goods. What's my collateral? It's interested in the value of the goods as collateral. And the transaction premium clause is in fact protecting the very same thing. So now I'm going to come on to the narrower issues of the sense of the transaction premium clause within the policy. And here the competing arguments are, on the one hand, our submission that there are other non-plod extensions, so it's not all that surprising to have another. And on the other, the underwriter's submission that this makes the policy radically different. So the starting point is to ask what are the add-ons, and I'll just adumbrate them without more detailed comment for the moment. The three dealt with in the judgment are the fraudulent documents extension, the business contingency cover, and the CEND cover under Section 3. But in fact, there were a number of other respects in which this policy granted very wide cover. The provisions also include the proof of goods clause at page 368 of the hard copy, and the missing goods clause just underneath that. And in addition, the cover includes war risks and strike risks. So perils ordinarily, well, which are excluded under the Institute cargo clauses, are here covered. So broad cover. So with that background, the question then is, how did these terms compare to the transaction premium clause? And my points in that regard are these. A, it doesn't really matter whether they're plod or non-plod. They are add-ons to the Institute clauses on any view. So they demonstrate a willingness by underwriters to go above and beyond ordinary cover. They pose much more of a problem for Mr. MacDonald-Egger's argument, because everybody accepts that they were valid and effective additional insuring clauses, and it's a problem for him in the context of his argument about subject matter insured that they're not separately mentioned. And that, we suggest, is why he has been so keen to recharacterise them as not non-plod. But coming on to my point B, he is wrong in saying that these are still physical loss or damage clauses. The width of his submission appeared to diminish somewhat during his oral submissions, and in fact, at first instance, it was common ground between the parties that they were all three non-plod extensions. And you'll see the judge record that at paragraph 210, page 78 of the judgment. And in relation to the fraudulent documents clause, that followed direct question asked by the judge of Mr. Parsons, then appearing for the underwriters. And at paragraph 236, the judge records specifically that Mr. Parsons accepted that the fraudulent documents clause included a non-plod provision. So it's not clear why or on what basis underwriters now resile from that to the extent that they do. But we say when you look at the fraudulent documents clause, it is clear in particular from clause 16.3 that it is not limited to physical loss or damage. It uses the words direct financial loss as opposed to 16.2, which uses the badge physical loss. So under this policy, when the parties mean physical loss or damage, they say so. When they mean financial loss, they say so, as they do here, as they do in the transaction premium clause. The whole purpose of a clause such as this, with its additional definitions in 16.4 and 16.5 counterfeit documents, is to meet the Engelhardt situation where you appear to have a bill of lading or other document of title for goods that look perfectly fine, but having purchased copper ingots and holding documents of title to copper ingots, you open the containers and you find per Engelhardt slag, valueless slag. That was the problem in Engelhardt. That was the problem that this clause addresses. Then Mr. MacDonald-Egger's maintained that the CEND cover wasn't concerned with physical loss or damage. Sorry, is concerned, wrong way around, is concerned with physical loss or damage. I just want to take you here very quickly, please, to the Bamburi, which is one of, I think, 7 new authorities before you, but not before the judge. Because this is the authority that he relied on in relation to the proposition that loss by detention is physical loss or damage. It's tab 3, and I just want a very short passage at page 32 of the bundle. So in the right-hand column, page 32, the judge sets out a clause from the charter party that he was looking at there. And then he says, just underneath that, there's a paragraph starting, it was accepted as a general proposition. And then 4 lines down, but there was argument as to whether this clause covered a loss by detention as well as physical loss or damage. So actually the judge in this case wasn't saying, as it was characterised by Mr. MacDonald-Eggers, that loss by detention is physical loss or damage. He was just saying it's loss. And that's not surprising because the section of the Marine Insurance Act he was looking at, section 60, deals with loss. You won't find the words physical loss or damage in the Marine Insurance Act, it's just loss. Now, the reason that I'm taking the time to take you there is that it shows just how tangled underwriters' construction has to become when you look at the transaction premium clause. They squarely put their submissions to you on the basis that the transaction premium clause is limited to physical loss or damage. But surely it's got to cover all heads of insurance under this policy. So actually, do they really mean that when it says default for whatever reason, they mean for whatever reason so long as it's either physical loss or damage or delay? It just doesn't work. There is no reason for restricting the transaction premium clause in the way in which underwriters suggest. Then thirdly, I think I'm on C, the commercial purpose of the add-ons is in fact like, not to say very like, the transaction premium clause. Now, I've touched on this already by talking about the bank's interest in the collateral. Under the fraudulent documents clause, the bank is receiving cover for the problem that it believes it's got collateral for its loan, but it hasn't actually because the goods are non-existent. In that case, the bank's loss will be the whole value of the goods that it's purchased. The problem that the transaction premium clause is dealing with is one where you don't make enough from your resale. You're left holding goods, you have to enforce your collateral, and you find that you've got a shortfall. That's the interest that the transaction premium clause is ensuring. So it is similar in its nature to the interest insured under the fraudulent documents clause. Then my point D here is that none of these add-ons were separately rated or the subject of additional declarations, with the exception of the business contingency cover, which does provide for separate declarations. So here we have a policy which covers war risks in the form of CEND, it covers it covers war risks, strike risks, CEND, it covers fraud. No separate declarations, no separate ratings. Why should the transaction premium clause be read as something other than an insuring clause just because it doesn't have separate rating, given that none of the others do either? So, pulling the threads together on commercial sense, we have the commercial sense and factual matrix arguments again arise in the context of the reasonable reader. So the underwriter's submission has to be, well, this policy is so absurd if the transaction premium clause is a freestanding credit risk that that just can't be what anybody meant. But that submission simply can't be made on the facts here in light of the evidence about how everybody understood it at the time. The brokers, the lawyers, the bank, they read this as credit risk cover. Nobody said, well, hang on, don't we need some extra declarations? Well, hang on, what about the rating? Wasn't said. So the points defy the facts. But moving on to my fourth and last point under this heading, it just can't be said that the transaction premium clause is in some way unworkable as a credit risk cover. And I am, just to pick up the question that my Lord Justice Edis asked, I am using credit risk cover as a slight shorthand in that the peril of default is perhaps more broadly drawn than under a credit risk policy as such. But this isn't a case where the language must have gone wrong because the contract is unworkable. The underwriters received declarations which identified the goods by contract number, counterparty, and price. There was no information, nor do they say that there's any information, which was essential for a bargain to be made. And whilst it can certainly be said, well, there might be some more information which would be relevant to a credit risk, precisely the same can be said about war risks, the CE&D cover, and so on. So it's a point that really doesn't run. So those are my submissions about factual matrix and commercial sense, which brings me then to the last main heading, which is the underwriter's new arguments about subject matter insured. As you know, this isn't a point that was run in front of the judge, and in our submission, the argument falls firmly into the category of an attempt to find a technical legal reason why words must bear a meaning which would surprise the reasonable lay reader. In essence, this is an argument that particular words have to be used to create non-physical loss or damage cover under a marine policy, an otherwise marine policy. It's a magic words argument. They say as much in their skeleton argument. The argument is and always has been, again, Mr. Parsons was explicit about this in front of the judge, that the clause would have to say irrespective of physical loss or damage. But there is no such rule of construction or marine insurance law in our submission. There are these two rules. First, if goods are insured against physical loss or damage, the indemnity paid will be their market value unless you say otherwise explicitly. So you've got to say so if you want to insure profits as well as market value. That was the point in Morris and Goldsborough Mort, whereas Lady Justice Andrews observed the policy said not including profit of any kind. So it was unsurprising that profits were not insured. That line of authority and that rule is of no relevance to this case because on any view, not only the transaction premium clause but also the basis of valuation clause explicitly insure profits. That's an end of that point. Then the second point is section 26(1) of the Marine Insurance Act, which does indeed say that the subject matter insured must be designated in a marine policy with reasonable certainty. So, first observation is that the statutory requirement, if this provision applies, is one of reasonable certainty only. No higher, no rule that particular words must be used. Certainly no rule that if you wish to create something other than physical loss or damage cover, you must say so explicitly. And I would invite you to look at section 26 as a whole. The other provisions are concerned with what you don't say, don't have to say. So the high point is section 26(1) with reasonable certainty. Then there are other provisions about not having to specify the interest. That's why I said it was really an anti-technicality provision. Then there's Mr. McDonald-Zerger's reliance on the Frio Chile. Lady Justice Andrews correctly identified the only statement of principle in the case, which is at page 184 of the judgment, where Mr. Justice Coleman said that it is always a question of construction. All I want to add on that case is that the interest at the top of the policy was frozen meat. But that alone was not regarded as conclusive by Mr. Justice Coleman. The reason for his decision was that when he looked at the insuring clauses, which were indeed the standard marine risks and some meat clauses, they were all about things like bone taint and refrigeration. So they were all about frozen meat. They weren't anything to do with the EC subsidy. And that was the point. It was apparent, construing the policy as a whole, as you have to, as the judge did here, that all that was intended to be insured in that particular case was the peril of physical loss or damage to the goods themselves. So the authority doesn't go beyond its facts. It's therefore rather unsurprising that it hasn't been cited in other cases until now, as far as we can see. It's just another way, the subject matter insured point is actually just another way of begging the question, are the words of the transaction premium clause sufficiently clear to ensure the transaction as well as the physical goods? Mr. McDonald-Eggers, I think, accepted that towards the end of his submissions. If you conclude that Section 4 is clear, then you will also be concluding that the subject matter insured is identified with reasonable certainty. And I repeat the point that if you look to see what the subject matter insured under this contract is, Section 1 is where it's said to be defined. Section 1 as a whole is headed subject matter insured, and that is where you find the transaction premium clause for the first time of asking. So, my lords, my lady, it's something of a gallop. Those are the reasons why we submit that the judge was right, both in saying that the transaction premium clause was clear in its own terms. You repeat where I started. If you excise it from this policy, one would have no doubt whatever about what it meant. But secondly, also the idea that it's some form of top-up or supplement to the basis of valuation clause doesn't work. In their skeleton argument at paragraph 9, the underwriters summarise what they say are their alleged grounds of appeal.
I don't know if you can have alleged grounds of appeal. I think they either are grounds of appeal or they're not. But
You're quite right. Yes, yes.
even I would
Once
be that
they allege are
unkind
good
to
grounds
Mr.
of
Eggers.
appeal. Assert, perhaps, are good grounds of appeal.
Yeah.
So, they list their grounds of appeal.
Yes.
The fourth and fifth of those refer to the language of the transaction premium clause and the entirety and structure of the policy. But those matters are, in our submission, wholly one way. The language of the transaction premium clause itself is clear.
Which page is the grounds of appeal there?
I'm sorry, it's tab 19, page 503.
I think it was
Page 509 of the PDF.
unusual to put your grounds of appeal so far back in the bundle, but anyway.
It's a skeleton argument. That's a reference to the skeleton argument, though in fact precisely the same text appears in the grounds of appeal.
Okay.
So grounds 4 and 5, as I say, are about the wording of the policy. We submit that those are one way and are not a good basis for saying the judge was wrong. As to 1 and 2, the factual matrix and the nature of a marine cargo insurance policy, Those were not matters overlooked by the judge. They were properly considered by him in accordance with the principles of construction, the very well-established principles of construction. That leaves only little 3, the correct identification of the subject matter of insurance. But for the reasons that are given, that point adds nothing. It is simply another way of framing the question, are the words of the transaction premium clause sufficiently clear? So on analysis, there is nothing in our respectful submission in the grounds put forward by the appellant.
Thank you very much, Ms. Clare. Yes.
My lords, my lady, I'm very grateful indeed to Miss Clare for sharing her arguments and discussing them with me over the last time preparing for the appeal. And on behalf of my clients, Edge Brokers, I adopt all of them. I have 2 very brief additional arguments that I would like to address to your lordships, which I can, I think, cover within 5 minutes, if I may.
You may.
First of all, in relation to a debate that developed this morning in relation to Mr. McDonald-Egger's submissions about the types of peril that can be covered under a marine policy, and a question from your lordships as to whether the Marine Insurance Act actually circumscribes the ability of parties to a marine policy to agree other types of perils. In our submission, no, because Clause 3 of the Marine Insurance Act at page 2 of the PDF of the construction authorities defines marine perils, saying that they're perils consequent on or incidental to the navigation of the sea, and gives the examples, but then says, and any other perils, either of the like kind, or which may be designated by the policy. So even the Marine Insurance Act apprehends, or apprehended in 1906, that one might decide to designate by the policy perils of a kind that weren't of a like type.
It would be extraordinary if it were not so.
Well, indeed, my lord, and that was the first very brief point.
Thank you.
The second point I wanted to make was a slight development of something that Miss Clare has cantered through, and I want to develop it partly because it is also relevant to the estoppel appeal. And that is the fraudulent documents cover and the changes that were made to that in January 2016. Miss Clare has already explained to your lordships that it was conceded before his lordship by Mr. McDonald-Egger's predecessor, Mr. Parsons, that clause 16.3 of that cover was not limited to physical loss and damage to goods. And at paragraph 211 of the judgment, on page 78 of the physical bundle, or page 80 of the PDF, the judge considered and discussed that change and explained that the wording had been expanded in the endorsement signed by Mr. Beattie in July 2015 and then incorporated in its expanded form into the policy subscribed by all underwriters in January-February 2016. Its effect in broad terms was to provide cover in circumstances where the bank had been a victim of a fraud. The expansion of the cover in 2015 to 2016 reflected a widely known problem at that time, referred to at the trial as Jingdao, where a company deployed fraudulent duplicate warehouse receipts to raise trade finance secured against the same stockpile of cargo. Multiple versions of the warehouse receipts were fraudulently created for the same parcel of goods, leaving numerous insured suffering loss in the absence of any physical loss or damage or theft of the goods. And that was very much part of the matrix when this extension to the cover was broked in January-February 2016. What also happened in January 2016 was that underwriters were asked to remove a previous $5 million sublimit for the fraudulent documents cover and to extend that cover without any limit at all, i.e. for the entire policy sublimit. In January 2016, the policy sublimit was for cargoes in warehouses, which is relevant for the Jingdao situation, $100 million per warehouse for soft commodities, but at the same time they agreed to extend it to $250 million per warehouse for oil and energy commodities, and they agreed to do all of that without asking for any additional premium whatsoever.
They wanted the business.
Well, perhaps. And in that context, my lord, when he deals with the as-expiring representation, which I'll come on to on the estoppel appeal, and matters that were considered within Ark underwriters, the judge noted that the Ark underwriters not only discussed with the broker, but they had an internal peer review, and that they raised a concern about that. And that concern is in the supplementary documents bundle, very last document in that bundle, tab 21, page 203 of the supplementary bundle. It's an email from Mr. Dawson of Ark to Mr. Blewett, and he sets out a variety of things that he's looked at for the peer review. And he says, also, isn't removing the fraudulent document sublimit a bit hairy? Limit seems to apply any one warehouse. Can the limit stack if there is fraud, confiscation, etc. across several warehouses, say in the same country? There are 15 warehouses scheduled in China, and that's a reference to the schedule of warehouses in the policy. And I draw your Lordship's attention to that, as I say, partly in relation to commercial absurdity. They're perfectly willing to stack up 15 warehouses at $100 million a warehouse or $250 million a warehouse for the Jingdao problem for no additional premium. And as I say, when I come on to the estoppel appeal, that may be irrelevant, and I'll certainly be saying it is, when one's looking at what representations were made and what they were meant and what they were understood to mean. And subject to those 2 points, I gratefully adopt Ms. Sinclair's submissions on behalf of my client also, unless I can help your Lordship and your Ladyship further.
Thank you very much.
My Lord and my Lady, I'll try to keep my reply as brief as I can, so I'll be a few minutes though. The first point, and these points are taken in no particular order. Just to make it clear, and just to repeat, the Engelhardt approach to construction is that in order for a marine cargo policy to cover non-physical loss or damage, non-physical loss, the wording needs to be clear. Section 26, which requires the subject matter to be designated with reasonable certainty. Now, that, of course, also is a requirement of clarity, but they're both aimed at two different things. One is aimed at identifying the scope of cover. The other is identifying the subject matter of the insured. So just because you tick box 1 doesn't mean you've ticked box 2. They're two separate requirements. That's the first point. The second point is my learned friend Ms. Sinclair did say that the TPC had been drafted by the bank's lawyers with some care. But of course, one needs to look at the policy as a whole. And this is a policy, as my Lord, the Master of Rolls, indicated, which has been thrown together in a sense that perhaps a well-drafted clause has been inserted into a policy, a slip policy, which has a number of different provisions, has errors in it referring to wrong clause numbers, and all has a number of clauses duplicated in different sections, not just the TPC, but also the limits provision and also the basis valuation clause. So the nature of the slip as a whole should be considered when undertaking an exercise in construction. My learned friend also took the court to the basis valuation clause, where there's a reference to the call option in the definition of what may identify the relevant market price. But what is important there, and perhaps it's worth just having the basis valuation clause to hand. It's in the core bundle, tab 10, page. I mean, you've got a choice between 362 or 368. Doesn't matter which. And the key point I try to emphasize during my submissions is that the basis valuation clause is focused on the purchase by the bank, whereas the TPC is focusing in terms of identifying the loss, in terms of the potential sale, or the actual sale by the bank, but also the pre-agreed sale price. They're looking at two different things, and they work in harmony if you look at both as measures of indemnity. And as far as the basis valuation provision is concerned, that construction is well borne out by the opening sentence when it refers to the date of purchase, and lower down when it refers to the purchase contract, the call option contract, or any other document relevant to the purchase. Now, any other document relevant to the purchase means the document by which the bank has acquired the goods, not by which they sell the goods. I began, but just towards the end of my submissions, after I finished with what I would describe in my very modest way as a flourish, my learned junior reminded me to remind the court about something, and I did, but I did it in a very ineffectual way. My learned junior reminded me that this is just for your note, you don't need to look at it if you don't wish to now, but it's paragraphs 296, 297, 303, and 310 and 311. What the judge said there was that one of the issues was whether or not the inclusion of the TPC in section 4, which had been included by way of an endorsement agreed by the leading underwriter and by two other underwriters, was binding on the rest of the market. And he concluded that because the term in section 4 did not increase the financial exposure in relation by reference to the TPC in section 1, therefore it was binding on the following market. And the reason for that is, if it didn't increase the financial exposure, then the authority granted to the leading underwriter under the general underwriters agreement was effective. So the judge had reached, on that analysis, the judge had reached a view as to the meaning of the location of the TPC in section 1, and said because the location of TPC in section 4 added nothing, then it was binding on the following underwriters, except for two who had already signed independently. I think my learned friend, Ms. Sabinclair, also went in the same document, page 361, took the court to the definition of interest, where it says all goods or merchandise appertaining to the insured's business for which the insured is the legal owner or for which the insured is at risk or responsible contractually or otherwise. Now that phrase really adds nothing other than to identify the insurable interest of the insured in property. It's a classic phrase in any Bailey insurance, and of course they're described as legal owners as well. So it's possible the bank may use Bailey without ownership, but because they're contractually responsible for the goods and their safety, then that gives them an insurable interest. It doesn't do anything more. It doesn't broaden the range of the interest being insured. It's still limited to goods, and it's the insurable interest in those goods which matters. And to make the point once again, of course, it's that definition of interest which is expressly associated with the definition of subject matter in the heading of section 1, which identifies the subject matter of the insurance. Ms. Sabinclair, I think, referred to the views of a number of witnesses. I think she referred to brokers, lawyers, and the bank, who expressed the view as to the meaning of the provision. Of course, she, quite rightly, began that submission by saying, well, it's obviously something which is not relevant to the question of construction. I would emphasize, of course, it isn't. It's not, that is not a matter for this court to take into account. What this court has to take into account is the factual matrix, the relevant context, the commercial purpose, and also, not least, the wording of the relevant provision, as well as the policy as a whole. I think I've accepted throughout that it is perfectly possible to have supplementary add-ons which are not physical loss or damage, but they're closely related to the adventure, and that's not unusual. But it's because they're closely related to the adventure which matters. And as you know, I say that the TPC goes well beyond that. I've addressed the court in relation to the fraudulent documentation clause, which, as I say, deems ownership, the existence and condition of the goods, and therefore treats it by way of a deeming provision as if it were a property insurance. As regards the confiscation provision, my learned friend took you to the decision in the Bamburi. If I just ask you to take that up. It's the authorities bundle, tab 3, page 32. And this was the case about the detention of a vessel in the Shatt al-Arab during the commencement of the Iran-Iraq War in the early 1980s. One of the arguments which had been raised was, well, even though the vessel was detained and therefore the insured had lost the use of the vessel, the fact that they were still receiving hire for the commercial employment of the vessel meant that somehow or other they haven't been deprived of the use of the vessel. And my learned friend took you to a passage on the second column towards the bottom of the page where Mr. Justice Staunton referred to an argument as to whether the clause covered a loss by detention as well as physical loss or damage, so thereby distinguishing detention on the one hand and physical loss or damage on the other, and whether the clause was operable because it was circular. And the judge said, I do not rule upon those arguments except to say that I doubt if I should have held the clause to be circular and therefore unworkable. But what the learned judge is not doing there is drawing a distinction between damage cases, which he describes as physical, and loss of use cases or deprivation cases, which he describes as something else. They're all treated as a matter of a property policy as a total loss, and therefore it should be covered. And in dealing with the argument as to whether or not the payment of hire during the detention of the vessel in any way prevented it from being a total loss, or there being a loss by deprivation. You can see at the top of the column, well, sorry, at the bottom of the first column, Mr. Justice Staunton said, it was said that these facts have a bearing on the question whether the claimant has been deprived of the possession of the vessel, but in my judgment they're plainly irrelevant. In the course of the argument, I asked Mr. Pollock whether the crew had been altogether excluded from the vessel by the Iraqi government. He would contend that there had been no loss of possession because hire continued to be paid. He replied that he would not. Another way of testing the argument would be to consider two vessels alongside each other at Qazar, both forbidden to leave, one under charter and the other not. I do not see it could be possibly said that the owners of the second vessel have been deprived of possession. Insurers may well have been entitled by virtue of the doctrine of subrogation to claim payment of hire during the detention. I was not asked to investigate this in detail. In all other respects, the charter party and the payment of hire under it are irrelevant to the present problem. In particular, I reject two specific arguments of Mr. Pollock. First, that the payment of hire during the first year of detention made it impossible for the claimants to take that year into account in assessing what is a reasonable time within which recovery must be unlikely. And secondly, the payment of hire highlights the somewhat fuzzy nature of the argument by which loss of use is equated to loss of possession. On the second point, I find no difficulty in discerning a sharp borderline between physical loss of use and financial loss of reward. So even Mr. Justice Staunton treated the loss of use or deprivation case as a physical loss. Yes, my learned friend Ms. Southern-Clare also referred to Section 26 and the succeeding provisions of it. And it's fair to say that there's a great number of authorities which consider the succeeding provisions, unlike Section 21.6.1 itself, which is reasonably clear. But what the other provisions are really getting at is there being no need to identify the insured's insurable interest in the subject matter. But what is required is that the subject matter itself must be designated with reasonable certainty. I think Ms. Southern-Clare said Frio Chile hadn't been cited subsequently, but it has, and in particular in a case which is in your bundles, which is called Shell against CLM, where it was referred to, where the same sort of issue arose, but in a different context. I think it was my learned friend Ms. Healy, I think, who raised the question about Section 3 and the broad definition of maritime perils, I think towards recently, where it includes perils designated in the policy, and that's absolutely right. That's why I said the definition of maritime perils is expansive. But what remains important is the definition of the marine adventures, which are referred to in A, B, and C. And of course, B is concerned with the loss of any pecuniary benefit by reason of insurable property being exposed to maritime perils, whatever those maritime perils may be. And I think then finally, Ms. Healy referred to, I think, a peer review in relation to the FDC, the fraudulent documentations clause. But that came after the event and really shouldn't add anything to the questions which this court has to take into account. And moreover, it's obviously the internal communications of one party and nothing more. So, my lords and my lady, for the reasons I expressed during my main submissions and also to the extent they're supplemented by my reply, I would ask this court to allow the appeal on the question of construction. And unless I can help you further, they're my submissions.
Thank you very much. Good. Ms. Healy, you're going to open the other appeal.
I would, and for this purpose, I'd quite like the lectern, if I may.
Of course.
So maybe longer than 5 minutes.
Well, we seem to have bought an hour and a half. No, an hour and 3/4 today.
I'm delighted.
And-
I've spent most of the last week desperately trying to make my submissions on estoppel fit into 2 hours, which
Well,
was rather a
I
tall
won't
order.
say take your time because that would be a completely uncharacteristic remark for me. But I suggest you agree to split the time pro rata,
Absolutely.
and I think that at least gives you the rest of the afternoon.
Well, I certainly won't finish
And then
today
you
and
can
wouldn't
decide.
be finished today on any view, my lord. The estoppel appeal is very interesting, and the bundle of authorities is twice as fat as for the construction appeal.
Is that you drawing a contrast, I do?
I'm saying nothing at all on that front. It's worth to my clients £3.5 million, for which they, to their surprise, went down at the end of what they thought was a rather successful 5-week trial on other matters, in which every single argument in the insurance textbook seemed to be raised, every chapter seemed to be raised in some respect. In contrast, the construction appeal is worth 10 times as much, and it's possible that that's why the parties' focus has been the way that it was, notwithstanding the number of legal issues raised. Also, when permission to appeal was granted by Lord Justice Mayles, he suggested that the construction appeal should go first. So
Well,
that,
I think he also suggested that the construction appeal only barely merited permission.
I wasn't going to mention that because I imagined that your
And
Lordship
he
might
said
have read that.
that your appeal seemed to have a real prospect of success.
Well, that was our feeling when we read the judgment, my lord. This morning, my own friend Mr. MacDonald-Eggers touched briefly on some correspondence that took place yesterday between Kennedy's and RPC. I apprehend that insofar as there's anything in it, it's a matter that I can deal with at the very end of
The
my
court has
submissions.
no interest in that kind of argument of any kind whatever. As far as I'm concerned, we've read the skeletons, they're there, and people can deal with them on their merits.
I'm grateful for that
I'm not
indication.
prepared to have the time of this court wasted with that kind of spat.
My lord, I'm grateful. I'll move on.
Yes, thank you.
So, how did the estoppel by convention rise at trial in relation to Ark and Advent? Well, my lady, my lords, you will appreciate from the sheer length of the judgment in this case, indeed the 3-page index to the judgment at the beginning of it, that, as I say, the trial covered just about the full gamut of topics that exist in insurance law, and we looked at just about every chapter of every book. And quite apart from insurers' arguments that on the construction, and it's true construction, the transaction premium clause, the TPC, didn't cover the bank's loss in this case, subject of today's appeal so far, the insurers unsuccessfully claimed that the policy should be rectified, that there was a collateral contract, thanks to an agreement between Mr. Mulliner, the brokers, and Mr. Beattie of RSA, that it should mean something different from what it said, or there was an estoppel about the meaning of the TPC itself, or by a relatively late amendment, only a few months before trial, that the entire policy could be avoided because the brokers hadn't told the underwriters what the purpose of the clauses that they handed over to them was intended to be.
And it should be rescinded for misrepresentation.
And that too, all of those arguments were run, and all of those arguments were ones on which underwriters were
I mean,
unsuccessful.
what one finds bizarre in this case is that having determined that the policy could not be avoided, that the policy was not vitiated by common mistake or unilateral mistake, effectively, or and had been affirmed in every particular. I don't think you can affirm a bit of a contract. I think you either affirm it or not. He then came to the conclusion that a sort of Johnny-come-lately of an estoppel by convention was not overridden by any of those things. And if he's right, then there is a problem for certainty in insurance contracts. I mean, one of the most important things for the market is the certainty of insurance contracts and the fact that underwriters can't get out of them just on some kind of idle discussion that takes place at broking, particularly when the slip is scratched, when the risk is written. And he said in terms, in about 5 places in his judgment, that it matters not whether the underwriter chooses to read the contract. As we all know, those of us that have sat on a box and seen it happen, they often don't. And they may have better procedures now than when I did that exercise, but I certainly know they often don't. And he found they often don't.
That's
And what I don't understand, and you'll tell me how he got to this, is how this part of his judgment, which is very few paragraphs, just 5 paragraphs, is consistent with all those previous findings.
Well, I'm not going to tell you that. I'm going to tell you quite the contrary.
Right.
But Mr. MacDonald-Eggers, I'm sure, will seek to persuade lordships and your lady of just that.
Yeah.
The point I was...
I mean, is there any insurance case in which, where all those previous arguments have been rejected and estoppel by convention has been upheld? And second question, is there any insurance case in which an estoppel by convention has been upheld?
Not that we're aware of. It's quite often run alongside a rectification case. And in those circumstances, sometimes it can be put in both ways.
Well, I can understand that. It's because if you look at it in certain ways, it could be said that they are similar sides of the coin.
Indeed.
If you have the circumstances that would give rise to a claim to rectify, you might also say that you've made out the basis for an estoppel by convention. But if you haven't got the basis for rectification, or if you haven't got a situation which would enable you to say one party was taking knowing advantage of the other party's mistake, for example, then, speaking for myself, I find it very difficult to understand how you even get to first base on an estoppel by convention.
Well, that was rather our reaction on getting to paragraph 692 to 702 of the judgment. Like everybody else, we looked at the last few paragraphs when we received such a long judgment and heaved a huge sigh of relief, because although it was said that our broking had fell short of the standards, and although we as brokers had gone into trial knowing that of all professionals in the world, we are under a unique duty to protect our clients, not just from other people making good arguments, but other people making arguments that turn out to be
You weren't
bad.
criticised, actually. I mean, all this is said to be entirely innocent, which is a very important feature, because if they had known that there was a misunderstanding, there would have been a case for unilateral mistake.
My lord, yes, and there were days, and my principal witness, Mr. Mullen, who was 76 years old at the time, was in the witness box for 3 days, being accused of exactly all of those things.
And get me started on how long this trial took.
Well,
how long the judgment is, because
but
that won't help anybody.
I mean, my opening submission essentially has just been made back to me in the form of questions by my lady and my lord. We were at a loss to discover that we had fallen down on this estoppel by convention in relation to these 2 underwriters, when it hadn't appeared other than in a brief roll-up. We are relying on every type of estoppel plea in underwriter's defence.
Well, it sounds as if it was Mr. Parsons sort of mentioned it in dispatches in the final submissions, and so the judge felt he had to deal with it. But what I find personally quite curious about it is that the two underwriters who don't bother to read the policy are able to take advantage of an estoppel by convention, whereas the conscientious one who actually does bother to doesn't get away with it.
I've heard a rumour to the effect that my lady is not the only person that thinks that, and there may be those in the market who think that's a curious result too. As I say, it's only a rumour, and I wouldn't know.
The problem with his lordship's judgment, which is, you know, I would say, irrespective of Mr. Eggers' appeal, is a good judgment and very comprehensive and well written and readable actually, and you know, has much to commend it. But this bit seems to come at a time when he seems to have somehow forgotten the very firm strictures he makes about how it does not matter if the underwriter reads the contract. That's his problem. If it were otherwise, the market would be in disarray. I mean, literally in disarray. And,
My lord, yes.
and then, and the other thing that I find totally bemusing is what is this conventional understanding? A conventional understanding is, I think most recently said by Mr. Justice Mann, is something that both parties share subjectively. I mean, we had this argument in a case called Daventry on the case of mistake, and it's finally been laid to rest by the case that Lord Justice Leggett, as he then was, decided with initials that FCHM or FSHM,
Yes.
I can't remember, but it begins with F. And it's been finally laid to rest, where in the law of mistake it is clear that you do not have a continuing common intention unless you actually have a continuing common intention, which bit of that lawyers didn't understand in the past, I've never understood. But the fact is that you have to have a common understanding for an estoppel by convention. And there wasn't here. So it's a representation case at best. And he'd already dismissed the representation case.
My lord, yes. All of those things I was going to say at much greater length, and I may be able to say more briefly. But what is most curious of all about this is that the judge found that this policy wording contained what's called a no avoidance clause, but it also had not just underwriters shan't avoid the policy for non-fraudulent representations, but underwriters shall not reject a claim on the basis of a non-fraudulent representation. And he found that that clause was validly incorporated. The insurers had signed the policy. It didn't matter whether they'd read it or not, see Graucob. That clause was not severable. It was enforceable. It was of type that was known in the market, CHIH and Chase, CHIH and Supreme Court and so forth. And yet, and it's not his fault because we didn't have submissions on this and we didn't expressly make the point to him, but yet he forgot that when he came to deal with his conclusion that there was an estoppel by convention by representation in relation to Ark and Advent. And that's our grounds 2 and 3 of the appeal. And the judge himself said at the consequentials hearing, when we sought permission to appeal, that although he thought we were wrong on the essential point about whether there had to be a common mistake and whether there had to be subjective acquiescence, if he were wrong on that, he wouldn't have had a problem granting permission on grounds 2 and 3, because they were plainly arguable and hadn't been, even though they hadn't been discussed at trial, he, I think, saw that there was something to argue about there. So that's where we get to on this. I apprehend from this morning's and this afternoon's submissions on the construction appeal that all 3 members of the court have done a great deal of pre-reading and have read the skeleton arguments and indeed are familiar with paragraph 303 of the judgment below. So I was going to take you through paragraphs of the judgment and the background. I don't think I need to do that in great detail, but I will, if I may, show you those that remind you of those that are specifically relevant to the findings on estoppel by convention.
What I would find helpful is that, and also the paragraphs that really cannot stand with paragraphs 29, whatever it is, to 303, so that the places where he really makes clear findings or holdings, which then he really must somehow have lost sight of when he came to find to uphold an estoppel by convention. So, I mean, I don't think there are there are all that many, but it is a very long judgment, and certainly it would be helpful for me. And
I think I've got those paragraphs in my note, but what we'll do overnight, because I'm not going to finish by 4:15, is
Yeah.
make sure that we put them in one side of a piece of paper
yes,
and
even
we
on
share
one
them with
side
Mr.
of a
McDonald
piece of
Eggers.
paper, or
and the
perhaps
court.
one
An
side
email.
of an email. Yes.
Obviously an email. I'm hiding my hard copy bundles here and just looking at the electronic
That's
ones.
right. Yes, I always take against counsel who use paper. I don't when it is. That's a joke.
So,
Ms. Heaney, just before you move on, could I just try and understand how this actually all happened? Mr. Parsons referred to paragraph 29 of the defence in the course of his closing submissions. You say you didn't make any submissions on the estoppel by convention, and then it just emerged in the judgment as a finding against you. How was it actually treated in the course of closing submissions?
that's a shorthand description of exactly what happened. Slightly longer than that. There's a paragraph 29 of the defence that says, furthermore, underwriters rely on estoppel, including every kind of estoppel, and you can't say that the TPC provided credit risks. And a paragraph 57 which said, and therefore the bank can't make a claim on that basis. We put that an issue in the pleadings. In our written opening submissions, we said that's not good enough. Estoppel has a number of elements. You have to say what kind of estoppel it is, what the elements are, what if it's estoppel by representation, what's the representation. You've got to have precision about it. You've got to have people saying what the detrimental reliance is for estoppel by representation and so forth. Nothing was then said about it in the context on which we have this appeal.
So the pleading wasn't particularised in the sense that one didn't get a response to that objection in the form of here are the factors that we say give rise to a common assumption or an acquiescence or anything of that nature.
No, and it's fair to say that both parties can be criticised to an extent with hindsight now that we know that the judgment has dealt with that, because we say my learned friends didn't explore the areas of knowledge needed for acquiescence and so forth, and get the answers they needed from witnesses. They say, well, you didn't specifically say in your submissions that needed to be done, but we had put it initial in the pleading. But there was, they do say in the pleading that there was a, quotes, as expiring representation. And it was pleaded that this 2016 policy is as expiring or nothing changed or as before, in relation to not just Mr. Blewett of Ark and Mr. Cook of Advent, but also, astonishingly, the lead underwriter, Mr. Beattie of RSA, who was the one that had all the meetings at which the TPC was discussed at great length and who alleged that he'd had a private agreement about its meaning. So that, perhaps unsurprisingly, didn't get very far. It was also pleaded in relation to Mr. Gager of Navigators, who duly read the policy and might perhaps be feeling aggrieved about the fact that that was, in a sense, held against him. But that was as far as the particularisation of the representation ever got. In closing, and we've given the reference in our skeleton argument, there was simply an oral submission by Mr. Parsons for underwriters. Oh, and of course we maintain our estoppel plea on the basis of as expiring, as was said to Mr. Beattie, and the same thing must follow for all other underwriters who received such a representation. And that was where matters lay until we get to paragraph 692 to 705 of the judgment on pages 192 to 194, and we were somewhat surprised to see those. And in those paragraphs of the judgment, and I think that at this stage the PDF is 2 pages ahead of the hard copy, so it will be pages 194 to 196.
And I'm using just a separate copy, so it's quite useful just to give me the powers.
The judge deals with this section. It's section, first of all, it's section F8, the as expiry misrepresentation. And that's paragraphs 647 all the way through to 682. And at this point, he was dealing with it as per all 4 of those underwriters and on the basis of a case of misrepresentation entitling underwriters to avoid the policy, not an estoppel. And this is where the bulk of the factual findings, insofar as there are any, as to what was said and what people understood, appears. And we see at 647 through to 650 the claim in respect of RSA that they had an actionable misrepresentation is easily dismissed. Then he deals with Mr. Gager of Navigators, and this is the first of the following underwriters who says, well, when a broker comes to me with a renewal policy, I normally say, has anything changed? What's different? Show me the changes. And he said that he normally did that as a matter of practice, and if nothing had changed, he'd only write relatively brief notes. This is paragraph 652. And his evidence was that it was presented to him on the basis that apart from an increase in the oil limit, the terms were as expiry. That's why he wrote a note saying all else as before. And Mr. Mullen, the broker, said he might have said all as before or all as previously agreed. And the judge found that Mr. Gager honestly thought and understood that. And over the page at 657, the judge found there was a misrepresentation.
Yeah.
And the representation was false because the midterm amendments that Mr. Beattie had agreed in July 2015 weren't binding on the following market, because when he agreed the midterm amendments, the document that he scratched didn't have the GUA box, and other amendments would have that box, and he would scratch saying agreeing on behalf of the market. Because the July 2015 endorsement was too big to fit into the template, and Mr. Mullen's not particularly computer literate, he put it in the Word document. It didn't have the box on it, and Mr. Beattie didn't indicate he was agreeing for anyone else. He signed and stamped every single page of it with his own scratch and RSA stamp, including next to the non-avoidance clause, and he was bound for himself, but he didn't bind the following market. And therefore, when Mr. Mullen honestly but wrongly broke to the following market the next year, when he told them that it was as expiry, they weren't bound to that. That was new for them. Those terms incorporated from that July amendment were new. And just for your worships and your ladyship's note, the July endorsement is in the supplementary bundle at tab 13, pages 119 to 121. And it's a 3-page document, and it's just quite useful for seeing what was new in January 2016 all in one place. And it included not just the TPC, but...
Sorry, did you say 119?
119 of the supplementary bundle for the hearing of appeal, the 2 appeals. And it may be that that becomes 121 because the index isn't numbered.
I think it is digital page 119. And it has the number 117 printed on the bottom right-hand corner of it, I think.
The document I'm looking at is 2 pages on from that.
Yes, it's the one headed attached to and
Yes.
forming part of.
Indeed. So that 3 pages there is a ready list of the things that Mr. Mullen and Mr. Lockyer erroneously thought were included in the expiring policy for everybody, but in fact were only included in the expiring policy for Mr. Beattie. And one can see that that included not just the TPC, but a proof of goods clause, amendments to the fraudulent documents cover that I touched on earlier to make sure that it covered the Jingdao situation, and then at the bottom of that page going on to the next, the clause, non-avoidance clause, saying that underwriters won't seek to avoid or repudiate the contract, but then saying also that underwriters will not seek damages for or seek to reject a claim or loss on the grounds of non-disclosure or misrepresentation other than fraudulent.
I mean, this is very much an insurance market. It's not, it's an insurance market.
Yes, absolutely.
Yeah.
So that was the document that Mr. Mullen and Mr. Lockyer had in mind, and the judge found that when he drew up the 2016 policy, Mr. Lockyer did his best to incorporate all of that in the 2016 document, that was then presented to all of the underwriters when they were first asked for interest in this policy.
What was the contract change made under endorsement 4 that was deleted?
That was the business contingency cover. The business contingency cover first got into the policy in 2014 in terms which, interestingly enough, said that it provided cover in the absence of physical loss and damage for the following types of delay. And that gradually got tweaked and changed and added to and amended. And in the course of those changes, those few words were removed. But it then lay in the policy, and no one actually ever made any declarations under it. There was a debate between Norton Rose and the bank as to whether it provided them with any useful cover or not for what they were concerned about covering. And therefore Norton Rose then drew up the TPC, and they kept the business contingency covered there. They didn't delete it, but they added the TPC, and the way that it came in was by deleting a previous version of the business contingency cover and replacing it with this
The
version
original
of the TPC.
Replacing it with the original business contingency.
No, replacing it with the TPC plus a slightly amended.
Oh, I see, plus slightly amended business
Yes.
contingency.
We did go into that in great detail in trial, but I don't think anyone suggests that that particular history is of great relevance to this appeal, because there's rather a lot of other matters that are of greater relevance. But anyway, going back to paragraph 657 of the judgment, the judge expressly states there in relation to Mr. Gager there was a misrepresentation. Mr. Gager was told the terms were expiring. It was false as far as he was concerned because there had been material amendments to the terms agreed. It wasn't alleged it was fraudulent for good reason. Mr. Mullen was proceeding on the basis that the July 2015 endorsement was binding on all underwriters, and that this therefore was a policy was a renewal and expiring terms except for those matters which he specifically identified. Now, Mr. Gager isn't the subject of this appeal because he unfortunately read the policy and therefore isn't able to, but he was the first of the following underwriters where the judge dealt with this issue, and in some respects the judge's finding of the facts as to what he was said and what people understood is clearest in respect of him at 657, where effectively he's saying that certainly Mr. Mullen is proceeding on the basis that as expiry means 2016-17 policy is a renewal on expiring except for those matters specifically identified.
He finds specifically no inducement, and what I quite find interesting is para 665. He says there's no inducement in relation to navigators, and there's no inducement because a very large group of people wrote the risk despite the fact that there was a change.
Yes, indeed.
So the fact that whether it was the same as last year's or not was neither here nor there. I'm paraphrasing.
Absolutely.
It
So-
really didn't matter in terms of materiality to the risk that was being written, whether they'd written the risk on the same terms last year or on different terms last year, because ultimately what they decided was to write it on the terms that were put under their nose, and it was up to them whether they chose to read that or not.
Well, I mean, that was our submission at trial,
Yes.
and largely we
It's
succeeded
accepted.
apart from
Apart from Ark
two
and Advent.
underwriters. But there's a wrinkle in it, and I'm sort of mixing up different stages in my submissions, but I think it's quite useful to have a debate about it because the points do interrelate. Whether one looks at an estoppel by convention or an estoppel by representation, you need to identify what the thing is that is said or assumed or understood or agreed. And I've read all the relevant paragraphs of this judgment on many occasions, and it's very difficult to pin down precisely what it is unless you, and I apologise for using this word, but unless you fudge it and say, oh well, everyone was told it was at expiring. But actually, that could mean different things to different people. Certainly, everyone noted down that some things were different. It was common ground at trial that there was a difference to the fraudulent documents cover, that the change had been made to deal with the Jingdao situation. A sublimit had been removed. It was no longer subject to the 5 million sublimit. It was subject to 100 million or 200 million per warehouse. There were...
When he comes to it, he says it's as expiry in the sense described in section F8.
Indeed, and one then struggles
And
to find what
F8
that
is
means.
Exactly, because F8 it deals with each of the underwriters in different terms and doesn't seem to describe what sense he's speaking about as expiry.
Precisely.
And anyway, it was as before for, I think, for Mr. Granger, wasn't it? And
Yes, as before, maybe as expiry, and even then there's qualifications on it. It's as expiry apart from the matters we specifically discussed, and apart from immaterial changes.
But the point you're making is that there must be a conventional understanding which has to be shared, and the judge never really identified what it was. Anyway, obviously not, because it was quite clear that the two sides thought as expiry meant something different.
Absolutely. Subjectively, they clearly thought it meant something different. He's found that in terms. And we say that's appropriate and admissible to take into account on estoppel by convention, just as it is in relation to mistake. And indeed, the only way that Mr. Blewett and Mr. Cook were able to persuade the judge on estoppel by convention was by saying to the judge, well, I subjectively understood this to mean that I didn't need to read the policy because there was nothing that I needed to read in it.
Well, that's why the judge goes down the acquiescence route rather than the common interpretation route. Because he doesn't find, as I read his judgment, that there was an estoppel by convention in the traditional sense of what some people call limb 1 of Lord Staines' analysis, which is that both parties both subjectively think that one state of affairs occurs, and in fact it's a different state of affairs, and then one of them tries to renege on that, and it's said that that's unconscionable. That's your classic situation. The subset is where one party makes the mistake and the other one acquiesces in it, in the sense of, I would have said, actively knowing that they're making a mistake, either eggs them on or fosters it, or does something else that makes it unconscionable for them to go back.
Well, indeed, and that's how we understand it, the law to be as well. And perhaps infelicitously in the grounds of appeal, I phrased that as being estoppel by acquiescence cannot arise where the parties are at cross purposes.
Well, it's common mistake. That's limb 1, and limb 2 may be unilateral mistake.
But there has to be a consensual element to it, and or there has to be acquiescence, and acquiescence requires knowledge.
Well,
Yes.
Exactly. The defendant has to know what the other side knows. That's the whole point of it. It's not
Absolutely so.
unjust to go back on it if you're both at cross purposes, because you don't know which side to say should be mulched in liability, as it were.
Well, that's the essence of our appeal on estoppel. And against me, it said, well, no, you were the one that made a positive representation, you were the one that said, as expiring. Well, it's a little bit unclear on the judgment, because some of the evidence was underwriters said, has anything changed?
But I mean, that's the whole reason why it's so important to look at what the judge said about underwriters needing to read the slip.
Yes.
Because, that is a well-established line of authorities, which I don't think anybody before us is seeking to change, which says that underwriters are hoist with what they sign, and any other course would lead to massive uncertainty in the market and be a disaster. So nobody's saying that's not the case, but he seems to forget that when he gets to saying, oh well, if somebody says something loose and they're still at cross purposes, the insured, really, not you, but maybe the broker later, the insured suffers, not the insurer. Well, that doesn't stand to any kind of analysis.
In our
It
submission,
doesn't
no.
stand together.
I mean, in any case of an insurance being placed, no, that's correct. But all the more so here of an insurance being placed with a non-avoidance clause that says underwriters will not reject a claim based on anything that's said
Which
to them.
has been affirmed.
Unless, which has been
Be
affirmed.
affirmed. I mean, that's the final nail, isn't it? The
That's the
affirmation.
I mean,
Yes.
it's
Well, that's
it's
what
quite
we
a
thought
strange
once
case.
we'd got to the paragraph just before the estoppel by convention section, because we really thought that we had.
I mean,
nailed
I've read
down
and reread
all the points.
paragraph 697 many, many times. And it's the final sentence that is very, very difficult to understand in the light of the fact findings that the judge has previously made. Because they all make an assumption that the terms that they were considering were as expiry or as before. And he explains in the case of Ark and Advent that what that meant was whatever it was that they had scratched in January at the time of the 2015 renewal, rather than what Mr. Blewett scratched in July because they didn't know about that.
Subject to
To the fact that
anything
they've
that
had...
they discussed
Yes.
and anything that wasn't material.
Right. So
So it's not even quite that.
not even quite that. And then that assumption was acquiesced in. Well, what does that mean? If you acquiesce in something, it means you've got to know that somebody's making the assumption, and you've got to agree that that's correct in some way, or hold out that it's correct in some way.
And
Now,
if
if you believe something completely different, and you don't actually say to them, by the way, Mr. Blewett, can we just get this clear? That what I'm talking about is this, or what you're talking about is this. And they're actually at cross purposes. How can you have the acquiescence?
In our submission, you cannot.
No.
And even if there were any doubt about that, or there was something to be argued about as to whether it's not sufficient because it was internal and subjective to Edge, that they thought it meant something different, all you need to look at is the fact that they've only said as expiring or as before on the very first occasion when they go to see these underwriters to gauge interest, and they discover there's so much interest that the slip's likely to be 130% oversubscribed. When they actually go back for the policy wording for the second time to get lines put down, it still contains the TPC and the NAC and the missing goods clause and the increased brokerage and the change to the fraudulent documents cover and the deletion of the limit. Oh, and the third time they present the policy wording, it also still contains all of those things. So every objective manifestation from Edge in between the initial "are you interested in this" and the final "put down your line" is completely inconsistent objectively with Edge sharing the mistake.
So was the slip left with them on the first visit?
Yes.
And how long apart were the visits?
Well, there was some debate about that. We've got a chronology attached to our skeleton argument, which is an extract from a much bigger agreed chronology that extended to many pages. And from that, you can see that there was an initial approach. This is at page 451A of the core bundle. Mr. Wright's given me a very jazzy note to tell me how I account for 457 of the PDF, because all the A's and B's apparently add up to another 6 pages of the PDF. So we see that on the 21st of January, Mr. Lockyer of Edge, who's the junior broker, takes a draft of the policy to Mr. Cook of Advent, and it's got both of these clauses. And that is the occasion on which Mr. Cook thinks he was told something about as expiring. Although of all of the underwriters who raised this argument, the evidence and the findings in relation to Mr. Cook as to exactly what the representation said or what was discussed are the most sparse of all. One can tell in relation to Mr. Cook that they certainly noticed the increase in the sublimit from $100 to $250 million, because that's in the underwriting notes.
Well, that's decided on the balance of probabilities by the judge at the end.
Well, true.
And he says he seems to have sort of slipped through on Ark's.
Well, perhaps, yes, but we certainly don't know very much at all about the conversation that took place on the 21st of January, but a draft is there.
There was some kind of peer
and you can
review
look at
in the office.
Then on the 27th of January, there's a broke to Mr. Blewett. And Mr. Blewett originally put in a witness statement saying, I recollect that it was Mr. Mullen who broke the policy to me on this occasion, and this is what he said. And he said, I was asked, is it the same as before or not? And Mr. Mullen put in a witness statement saying, well, on the 27th of January, I was in Amsterdam, so it certainly wasn't me, if it was that occasion. And Mr. Blewett said, oh, well, in that case, I don't know whether it was a different occasion of Mr. Mullen or perhaps it was Mr. Lockyer on that occasion.
Could have been a Zoom broke, could it?
Maybe not in early 2016. If one were talking about early 2021, almost certainly yes.
Anyway.
27th of January, it appears to be, on balance of probability, the first occasion on which Mr. Blewett sees it. And first of all, he gets an email attaching it. And then there's a broke, not just to Mr. Blewett, but his colleague, Ms. Rule, and he actually does put the line down at that point and enters a reference, and he stores the written policy on the file. Then, on that same day, Mr. Lockyer goes and sees Mr. Cook again with another draft of the policy, still containing the TPC, still containing the NAC and all the various other provisions. At this point, Mr. Cook puts down Advent's line, and he enters a reference. He stores a copy of the signed document on his file. And here we have all we know about the representation to him, that the representation or his underwriting notes, assuming they accurately reflect what was said to him, were as expiry but brokerage up from 22.5%. And he says he thinks he in fact made those notes not on the 27th of January, but when he first saw Mr. Lockyer on the 21st, and that he would have typed them up 6 days later. Then, again, before the policy is finally bound, there's a peer review at Ark, where another underwriter has a look at the wording. Then, what happened, on the 29th of January, my lords, you will have seen from the detailed chronological section of the judgment, that Norton Rose and the bank had a sort of flurry of esprit d'escalier, in particular the very diligent solicitor at Norton Rose, who on his way home one evening suddenly thought to himself, maybe we'd better make sure the TPC is placed where it's absolutely clear what it's going to cover. We therefore need to change it and put it in a different place. Now that's obviously completely irrelevant to construction, and I'm not suggesting that it is, but as a factual matter, that was what led to the scurrying around on the 29th of January, whereby the bank said to Edge, oh, we want you to move the TPC around. Mr. Mullen went to see Mr. Beattie, who sent him off with a rather dismissive response. The bank insisted. Mr. Mullen said to Mr. Lockyer, he will agree it, but got to go back. Mr. Lockyer then did incorporate the TPC in the two places. Mr. Beattie scratched it in the two places, put it on the file, said this is the working slip for this year. And then on the 1st of February, and I think it was a Friday to a Monday from recollection, Mr. Lockyer then sends an email to the whole of the following market in which he attaches the final wording with the TPC in two places. Now, because there were several iterations of the policy on the 29th of January, the final one of which merely corrected some typos, Mr. Lockyer's covering message said words to the effect of, here's the final version of the policy, correcting some typos. And one can imagine that led to rather a lot of trial time as to whether there was something in that or not, and there wasn't. All of the market then got that final wording on the 1st of February. Ark and Advent were bound, although, as I showed your lordships and my lady, in relation to the construction appeal, the following day, Ark's peer reviewers took a look at it and didn't like some of the provisions, in particular the hairy removal of the sublimit for fraudulent documents cover. And indeed, some of the other underwriters didn't like the look of the CND coverage either, because it was going to break their reinsurance limits given the removal of the increase in the limit to $250 million a warehouse for some cargoes. As a result, some of the underwriters had to come off. The brokers had to find some replacement underwriters, and they got Swiss Re and ProSite in because they had so many people interested. That wasn't a problem. So we ended up with some later broking. But so far as Ark and Advent are concerned, the essential chronology is set out here in Appendix 1, and whatever it is that Edge said about as expiry, as before, or whatever, they said it at the same time as handing over a policy document that wasn't as expiry, and they subsequently, the next time they went to see these underwriters, again handed over a policy document containing the TPC and the NAC. So that, in broad outline, it is the factual background to the findings that there was an estoppel by convention. And as my lady's already observed, the judge, having set out his various findings in section F8, that Ark and Advent had made an assumption that the terms they were considering were as expiry as before, except for certain matters specifically identified to them, found at paragraph 697 that that assumption was acquiesced in by Edge, and indeed was the result of positive statements made by Edge during the 2016 renewal. And on that basis, the judge found at paragraph 705 that the bank was estopped by convention from asserting, as against Ark and Advent, that the 2016 policy included cover in respect of credit risks and or financial defaults. That in itself is quite interesting, because the thing that the bank was estopped from convention from asserting was itself slightly different from the representation or the assumption that the judge had found to have existed, because nobody ever suggested that there was a representation or indeed an assumption that the cover either did or didn't include cover in respect of credit risks and or financial defaults. So that in sort of high-level summary is why we're here, and why Edge brokers, on whom the financial burden of this estoppel has fallen, sought to appeal and were given permission to appeal those findings in the judgment. After that introduction, I was proposing to go to in more detail to the different grounds of appeal and our submissions in relation to each. And just by way of a signpost, because I'm not going to get through it before 4:15, the order I'm intending to follow, subject to any questions and guidance from the court, is first of all to deal with ground of appeal 1, our argument that there's no basis for an estoppel by convention because on the judge's own factual findings, the parties were at cross purposes.
Well,
And
you
that
don't need to spend much time on that, because it's obvious.
Well, we say that involves a lack of knowledge in order to acquiesce and so forth.
Well, you might want to look at the authorities and the lack of knowledge.
Yes, I think we'll probably do that first thing tomorrow morning, because I'm going to sort of deal with the arguments in principle on the points, and now that I've got a little bit longer, I might be able to take a little bit longer to show you the authorities, and I'd rather do that in the most efficient way.
I mean, it struck me that part of the problem in this case might have been that there is a temptation for judges to find the authority that sets out the principles of, estoppel by convention, estoppel by representation, common mistake, whatever it is, and then just methodically go through them each in turn without giving any thought to what the previous findings they made in relation to previous lists of requirements. So that here, you've got rectification for common mistake alleged, you've got avoidance alleged and findings made, and you've got affirmation alleged and findings made, and then when you come to consider afresh a new list of requirements from an authority that you pulled out of the latest Supreme Court book, you don't think, well, is that really consistent with what I've said before? And that's what seems to have happened here.
Well, I think that's almost unfair to the judge in
Right.
this sense. Nobody actually argued or took him to detailed authorities on estoppel by convention. With
No, but he had in mind.
He did
Lord
have
Steyne.
it could be a common assumption or
Yeah.
an assumption of
He had
one
in
shared
mind
in by
Lord
the other.
Steyne's requirements and
Yes.
the two types. I mean, he wasn't at fault in the legal requirements, but
No,
it seems to me he was at fault, if he was at fault at all, in not matching up what he'd said before about the facts.
Well, that's our primary submission, and
And I mean, you'll think about it overnight, but what horrifies me from the point of view of running an insurance market, that's what everybody in court is doing, is the concept that you can, you can have all this fantastic learning about avoidance and mistake and rectification and affirmation, and then all of a sudden over the mountain comes riding at fantastic speed some estoppel which has never before been used in the market, and rides a coach and horses, if my metaphors are not getting quite ridiculous, through the cover. And it would be quite serious if that were the case, because it would involve in every case going through these notes, which we know are exiguous in most cases, of underwriters, and interrogating some sort of idle conversation that takes place at the box, which, maybe on Zoom now, which would make the whole thing impossible. I mean, people have to be governed by what they sign, otherwise the market can't work.
Well, absolutely, and there's lots of insurance law learning that
Says
doubles up and backs that up. Section 18(3)(c) of the Marine Insurance Act
Exactly.
1906 says that you don't have to disclose to insurers things they're presumed to know.
Yes.
And one of the things they're presumed to know is
What's
your own
in the slip?
business. And they're presumed to know, as the judge found in this case, what's in the slip.
Yes.
And yet, if somehow, by an estoppel by convention, the bank cannot rely on what's in the slip, even though insurers are presumed to know it under a statutory provision, that's a very, very strange state of affairs. So, I mean, that's ground one. Grounds 2 and ground 3 are with bells on in this case because the judge found that the policy incorporated properly and validly the, what everyone calls non-avoidance clause, because that was the heading, but the clause that says insurers will not reject a claim on the grounds of a non-fraudulent representation. And if that was the case, how on earth could they say, well, we're not paying this claim because you, the bank, have stopped by convention from saying there was credit cover because it was represented to us that the slip was the same as last year, even though it wasn't. And that comes up at ground 2, specifically with reference to the non-avoidance clause. And ground 3 is an overlap. We say, well, it wasn't unconscionable in circumstances where there's a Graucob principle that in the insurance market, along with other commercial contract markets, people are bound by what they sign.
But how can it be an injustice to hold people to what they sign?
Absolutely.
When the law is that you are bound by what you sign. I mean,
there's a wrinkle on that my learned friend will no doubt want to develop. It's referred to, I think, in Springwell and the Higgins case. Lord Justice Popplewell's judgment is cited in that with reference to something that Lord Justice Mance said about, well, the Graucob principle doesn't apply where a misrepresentation has induced a contract. But
well, of course
that
it doesn't,
can't be
but
just any casual comment that's made to somebody. It would have to be a misrepresentation that bites in law.
No, of course it doesn't, but it has to be an operative misrepresentation.
Absolutely.
That allows the contract to be either rescinded
Rectified.
or it's fraudulent, and you can have damages for fraudulent misrepresentation. But it's then you're into a clear misrepresentation case, which the judge decided against them. I mean, it is we do have to have regard to principle here, because the law it is absolutely fundamental to not only the insurance market but the commercial market generally, that the law of contract is clear and understood by all participants. And the law of misrepresentation. I was learning the law many years ago. We had marvelous fun with the law of misrepresentation, which was undergoing, what should we say, seismic change. Well, that's sort of disappeared then. Then we had the seismic change to the law of mistake, which now seems to have subsided. And through all this, not being difficult about it, but the last resort of every defendant is usually estoppel. But estoppel is not a panacea to overcome the other principles of the law of contract. So what we've got here is the very same facts having been rejected in misrepresentation, mistake, and affirmation, and then coming back in the form of an estoppel, which would be very surprising indeed, and particularly for the certainty of the common law. And that's why we need to be so careful in looking at all these authorities, which, by the way, are mostly non-contractual cases.
Absolutely, my
And they're
lord.
nothing to do with this at all. You know, HMRC and bench dollar is absolutely nowhere near this case. And Tinkler is the same. The only one, I think, of the trio
No, sex
is
pistols,
the
my lord.
Hilliard case. What's that called?
Sorry, it's called Jones and Langdon, but it's the bust-up between the former members of the band, the Sex Pistols.
That's right.
As to
which
whether
is-
a band member agreement, which provided for a sort of majority veto, was something that the majority could rely on in order to allow the memoirs of one of them to be turned into a television series by a very well-known producer,
Well-
or whether another of them could say, no, I have a right of veto. And that was contractual. And actually, we'll look at the judgment on that tomorrow, because that's actually one of the most relevant.
Yes.
But
But it
the-
was contractual.
it was contractual, and the judge made it absolutely clear that one of the reasons why you need to have either a common assumption or knowledge to acquiesce in another assumption, and it's also been said why it's so rare, is that in a contractual case, the parties need to know where they stand. They've agreed the terms of the contract,
I
and
mean,
you
if
need
you look at-
something.
Yeah, I mean, that's right. But if you look at paragraph 78 of Lord Burroughs in Tinkler,
Yes,
where he says all these same principles apply in contract, I mean, a very dangerous thing for a judge to say when you're dealing with a non-contractual case. But even if he were right, they only apply subject to the law of contract.
indeed,
they
and
do
all
not-
the other principles. And what is so surprising about this judgment, which in many respects is it's going to be cited, and already has been cited in most of the chapters of most of the updates of most of the textbooks on insurance law, for the reasons we've already discussed. But on this particular thing, the judge reminded himself of the primacy of contract at paragraphs 467 and 472. He referred to the well-established principle of English law underpinning the whole of commercial life, that a person who signs a document knowing it is intended to have legal effect is generally bound by its terms whether or not he's actually read them. See Grauholt, see Springwell. And we are at a loss to understand why that conclusion and that reasoning didn't apply to...
Well, I mean, you're not completely at a loss. It was a very long judgment, and sometimes Homer nods, even with the
I was about
finest
to
of
say precisely that.
judges in the commercial court. But you say it's just, you say it just can't be right.
Indeed. My lord, yes.
Okay, well, there we are. Now, we're not going to look at any of these authorities tonight. Could we have a look at one of them, just to...
We absolutely can. Should we start with Tinkler, since that's the latest word from Lord Burroughs,
But it is a
and it's fairly hot
non-contractual
off the
case.
press.
Tab 15.
And this is in the Estoppel Authorities bundle, and I think this is the only one we've actually managed to get the page numbers and the PDF numbers to marry up, because somebody thought about numbering the index.
Don't get me started about that.
But it's page 523, tab 15. And as my lords, you will no doubt have noticed from the references to this case, it wasn't a contractual case. It was one of these instances where Her Majesty's Revenue and Customs sent a notice of inquiry to a taxpayer. In order for the notice to be valid, it had to be sent to the taxpayer's correct address. But erroneously, they sent it to a wrong address, a previous address for him. But they then started corresponding with his accountant, BDO, about it. And BDO didn't ever take any point on this, indeed, in the correspondence. So the Supreme Court justices found they actually actively proceeded on the basis that it was a valid inquiry. And there was
a common assumption by the agent for the taxpayer and the revenue that it had been a valid inquiry.
Indeed. So it was a common assumption case. It's not contractual. In that sense, factually, it is a far cry from this case. But it is the latest, most recent and most comprehensive thinking on estoppel by convention from the highest court in the land, and moreover, it most usefully encapsulates all the relevant little pieces of citation from the prior authorities on the topic. So it's quite a useful and easy place to start. If we look first of all at paragraph 21 on page 531 of the bundle, we'll see that the Court of Appeal had actually found against HMRC because BDO didn't have authority to receive the notice, and the Court of Appeal had concluded that BDO hadn't assumed responsibility for the common assumption. Ultimately, however, the members of the Supreme Court reached a different conclusion, as we can see if we go to page 534 of the bundle and section 7 of Lord Borough's speech, we'll see a section headed the case law on estoppel by convention prior to bench dollar, 6 leading cases. And in paragraph 28, Lord Burroughs observes, attempts have been made over the years to try to unify the various estoppels, but such unification has proved elusive, and the different types of estoppel continue to be seen as having their own particular requirements and effects. And we place reliance on that insofar as my learned friend Mr. MacDonald-Eggers attempts to refashion certain findings in the judgment to make good a finding of estoppel by representation, which has different requirements and effects from estoppel by convention when he comes to his respondent's notice. We say they aren't all the same, and indeed one of the reasons why perhaps the judge went wrong in this case was he perhaps mixed up there being a representation as a basis for an estoppel by convention without considering the need for there to either be a common assumption about the meaning of that or an acquiescence in an assumption about the meaning of that by one party knowing what the other party was assuming to be the meaning. The first case that Lord Burroughs deals with is amalgamated investment and Texas Bank, which I think anybody who studied law at whatever stage will be familiar with as the sort of high watermark of Lord Denning saying that all estoppels could indeed be.
Miss Healy, be careful. I studied law quite a long time before Texas Bank. However,
I always thought that compliments on the whole were accepted without qualification. But anyway, amalgamated.
but I remember it when it came out.
Indeed, was a case in which there was held to be an estoppel. In the case of Lord Denning, it was a general sort of estoppel. In the case of Lord Justices Evely and Brandon, it was an estoppel by convention, as Lord Burroughs observes. And this is a case in which both parties to a contract, one party both for itself and for its Bahamas subsidiary, and the other party being a bank, assumed that the terms of a guarantee extended to a particular loan, whereas strictly speaking on the terms of the contract they didn't. They didn't record their assumption properly in the contract documentation they were negotiating, and the bank continued to extend loans and grant time to pay. And then when the company and the subsidiary got into difficulties and tried to rely on the precise wording of the contract documentation, they were held not to be able to, partly because Lord Justices Brandon and Evely found that actually on the true construction of all of the contract documentation looked at together, it did apply, but if that was wrong, all three members of the Court of Appeal held that the company and its subsidiary were stopped from denying that the guarantee covered the relevant loan. That was a case with a very distinguished panel of judges at all instances. At first instance, it was decided by Lord Justice Robert Gough, who had said that the case wasn't a simple acquiescence, but was based on active encouragement and representations. And it was a case where both parties were making the same mistake. Just going back to the description of it, in Tinkler, as the first of the cases discussed in section 7,
Sorry, where are you?
sorry, I'm now back in Tinkler and looking at the paragraph 31 of Lord Burroughs, making it clear that Lord Justices Evely and Brandon making it clear that the relevant estoppel was an estoppel by convention, as a reference to Spencer Bower. And then paragraph 32, Lord Burroughs adds that it was no bar to the estoppel by convention that the mistake of the party raising the estoppel hadn't been instigated by the other party. And he refers there to how Lord Justice Brandon put it and the Master of the Rolls put it, with the latter, Lord Denning, saying it made no difference to the operation of the estoppel. The common assumption had been induced by a misrepresentation. So again, that's a case where there's a common assumption, and it's a very different case from the present, where two parties are making different assumptions.
It's also a case where if one of the parties had wanted to regularise the situation and on its true interpretation it didn't extend to the extra loan, they could have got it rectified, because they could have come to the court and said, we all believe that this covers the subsidiaries loan, and the answer would be yes, we do, and therefore you could have that written in and extended. So to a certain extent it's the other side of the coin. You could rectify it, and therefore you can't go back on the common assumption.
Absolutely, and in this case, as we know, because the judge said you couldn't rectify the insurance policy.
And likewise, you couldn't get it set aside for common mistake, because by the time, well, you couldn't get it set aside for common mistake because one party had acted to its detriment and the other party had effectively propounded the mistake, carried on with it.
Yes, that's right.
Encouraged it, if you like.
Yes.
It would have been inequitable to allow somebody to rescind it for common mistake in those circumstances.
So the next case that Lord Burroughs addressed was Keane and Holland, and I don't think there's anything in that is of great assistance or relevance to us. The next case was the august Leonhardt, which Lord Burroughs refers to at number 3, paragraphs 34 and following. And the next case, he says, focus on the issue left open by Keane and Holland as to what conducts required of a party who was allegedly estopped in order for the estoppel by convention to apply. The Court of Appeal made clear that the common mistaken assumption must be one that each party has communicated to the other. Now, in the present case, I think the judge, as I said earlier, using a perhaps infelicitous use of language, fudged, but he said, oh, well, there was a common assumption that was communicated because the words as expiry or as before were used. But in our submission, that simply isn't sufficient when it's an ambiguous and unclear expression, and it's absolutely patent that each party, in this case, thought it meant something different.
But all the stuff about the crossing of the line, which the parties seem to get so excited about, as they do in rectification, it's not really relevant here because there was no common assumption.
And the only thing that crossed the line was the thing that had the TPC and the NAC in it.
Well, that's true, but what also crossed the line was the representation that it was as expiry, which both sides thought meant something different, as the judge found.
Indeed. And in dealing with the reference to assumptions crossing the line and needing to have a common mistaken assumption, Lord Burrows said that what Lord Justice Kerr had meant was some mutually manifest conduct which is based on the common but mistaken assumption. And that's in the middle of paragraph 36, where there's quite a long citation from the judgment of the court given by Lord Justice Kerr, just above letter E on the left-hand side. Then, over the page at 37, paragraph 37 is the passage I just referred to, that was stressing that what Lord Justice Kerr meant by his use of the expression crossing the line was some mutually manifest conduct based on the common but mistaken assumption. And then the next case that Lord Burrows refers to is the Vistafield, which was a case about misunderstandings in relation to the chartering and sub-chartering of a vessel to carry mini metros to a demo so that British Leyland could show people just what marvellous cars they were. And problems arose in relation to the charter party and what had been agreed, and in particular as to whether or not, because this was an unusual arrangement, the usual commission that would have been applied was payable or not, and there was held to be an estoppel in which it was. But all that we get from it here is the very end of paragraph 38. The necessary requirement of estoppel by convention was that it must be unjust or unconscionable against the party against whom the estoppel was raised to resile from the convention. And as my lord has raised with me earlier this afternoon, we say that element is absolutely missing here. And if that were all that would, if one were able to have an estoppel by convention based on casual statements made at the underwriting box, that would throw coach and horses through many, many centuries of law on the meaning of contracts, contract certainty, and insurance contracts. The next case is perhaps the most important one in the sense that it appears to have been the most important statement of the existence of estoppel by convention, possibly a case that the judge, Mr. Justice Jacobs, in this case.
Was it cited to the judge, or did he get it out?
I'm so sorry, I didn't hear.
Was it cited to the judge, or did he get it out himself?
It was cited to him in the skeleton arguments.
In the skeletons, yeah. Okay.
And
we know that passage very well now.
Indeed,
so
and the authorities' bundles below were far larger than they are here, and it was in there. So that's the passage which appears to have been the basis on which the judge proceeded in this case. There's then a reference to the House of Lords obiter dicta application of estoppel by convention, Johnson and Gore Woods. I don't think we need to go there.
And actually, you look at that passage. Everybody's focusing on the passage that's quoted here between D and E. The assumed state of facts of law, the assumption being shared by both or made by one and acquiesced in the other. But look at the end of that passage. It is not enough that each of the two parties acts on an assumption not communicated to the other. It couldn't be clearer.
Well, here,
Which is
Ark and Advent say we acted on an assumption that, and again, what is the assumption? But for present purposes, I say we acted on an assumption that there wasn't a TPC in this policy, and we therefore agreed to scratch and agree it. But in Edge's submission, they didn't communicate to Edge that they were assuming there was no TPC.
We acted on the assumption that we acted on the assumption that we were writing a risk, which was materially the same as the risk that we wrote the previous January, apart from the specific clauses which had been drawn to our attention by the broker.
And certain other clauses that weren't material.
Well, Miss Healy, that might be a good moment.
I was just about to come on to bench dollar, and that's a slightly more pithy citation, and there was the subject of consideration of correction.
Can I just?
I think it would be a good moment if that's convenient, my lord.
Can I just say something? Unfortunately, despite COVID having assuaged, it is still a requirement that those not speaking do wear masks in court. I noticed there seems to have been a convention or an assumption in this court that it didn't apply to any of you, but I'm afraid it does. So can I ask that masks are brought with you tomorrow? Thank you very much, and we'll convene again.
My Lord, might I just raise one matter? I'm so sorry to detain you. You'll have observed that there's no skeleton argument from the bank on the estoppel appeal.
We did.
The bank is very interested in the construction appeal because some pockets are deeper than others, but the estoppel appeal has a much smaller sum at stake. So we are
You win either way, Ms.
We're
Sutton.
content to do this on that appeal. So the question, my Lord, is whether I should be here tomorrow. If there's any prospect of the court having any further questions on the construction appeal, I'd want to be here. But I'm concerned you might not be very pleased if I sit here all day.
We'll miss you, but you are very welcome not to come.
Thank you.
And
If my junior will attend, just in case there is. Thank you.
In that context, it may assist Ms Savinclair and those instructing her if I clarify that although we have optimistically said in our estoppel appeal, if we win, we'd like to have our costs pleased to be paid by the bank and or underwriters. Our suggestion that they should be paid by the bank is only on the basis that the court is troubled by the distinction between Sanderson and Bullock orders, and we'd be perfectly happy
well,
to
any
have
argument
costs
on
paid.
Anderson and Bullock orders will take place in writing after the judgment has been delivered.
Indeed, I thought that might be the case, in which case there's another reason why Ms Savinclair wouldn't need to attend in relation to that aspect.
Is it? Yes, Sanderson, isn't it? Sanderson, yes. Very good. 10:30.